Such a protection cannot be absolute in every situation. The valuable right of liberty of an accused person and the interest of the society in general has to be balanced. Liberty of a person accused of an offense would depend upon the exigencies of the case. It is possible that in a given situation, the collective interest of the community may outweigh the right of the personal liberty of the individual concerned. Granting bail entails the striking of a balance of proportionality in considering the right of the applicant who is presumed innocent at this point on the one hand, and the public interest on the other. The cornerstone of the justice system is that no one will be punished without the benefit of due process. Incarceration before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to ensure that the accused person will appear for trial and not to corrupt the legal process by absconding. Anything more is excessive and punitive. The general rule, in my view, is for the courts to try to strike a balance between the need for a tie to the jurisdiction and the right to freedom from unnecessary detention of an accused person before conviction, and the need to bear in mind the circumstances surrounding each case. Thus, in determining bail, public good as well as the rights of the accused person should be kept in mind. End of quotes. The accused person is alleged to have held himself out as an advocate and proceeded to represent some persons in court proceedings as such. Contention by the prosecution and the victims is that if granted bail or bond, the accused person is likely to continue in his scheme to the detriment of the public and administration of justice. Each case must be treated on the basis of its own peculiar circumstances. In this case, a person is alleged to have been a fake advocate. The case against him is highly publicized, and there has been media coverage and reporting of the case. The accused is alleged to have been a fake lawyer in an urban setting where access to public information is good enough. With the publicity that the case has had, it will not be easy, in my view, for the accused to appear in any court as an advocate and represent a litigant as such without any probing by the presiding officer of such court, if indeed he is a fake lawyer as alleged. I say this because the accused is still presumed innocent and the court is yet to hear any evidence against him, because at this stage, hearing has not commenced. With regard to safety of the accused person, I am guided by the decision of the Honorable Justice F. Gikonyo, J. in the case of Republic versus James Lesirongo Sito, 2022 EKLR, where he said as follows, I quote, at this age and time, it is disheartening and depressing that a community or group of people will haughtily express desire to harm or kill a person under trial who is by law innocent until proven guilty. Is not such an epitome of a criminal mind? Can one notice any difference between such persons and avowed criminal? Any such act to harm or kill a suspect should be liable to prosecution in criminal law. I have stated before, and I will state it again, that such actions are unlawful, barbaric, and uncouth, without any place in law and in the 21st century. The community in question should let the law punish the accused. This should stop And my view is that the ground that the security of the accused person is threatened by the members of the public or victim family should never be encouraged to be a ground for denial of bail. Otherwise, courts will inadvertently promote or condone violence, disorder, and usurping of law by individual or groups of people. And he continued to say, I quote, "In any case, it is the duty of the state to ensure safety and security of its citizens, including the accused person. The police should take appropriate measures to ensure security of the accused person. I therefore find the argument that the accused be detained for his own safety and security to be without any legal or factual basis, and I reject it." End of quotes. Also, in this case, given the fact that there is no allegation by the police that the accused person is likely to be harmed by any person if released on bond, this court would have no basis for having the accused person held in custody pending his trial for his own protection as sought. For the court to deny an accused person bail or bond pending trial on the ground of his own safety, there must be clear evidence of imminent danger or threat to his own safety, as was the case in the case of Republic versus John Gatembo Mwangi, 2018 EKLR, and I have quoted what was said. Submissions without such evidence do not suffice as a reason for denial of bail or bond to the accused person hearing. Next is seriousness of offense. Counsel for the prosecution and victim submitted that the charges facing the accused person are serious. Indeed, the charges against the accused person are serious and would attract stiff penalties if proved. As already stated, each case must be treated on its own merits and circumstances. While all offenses are bailable, seriousness of offense is still a consideration in determining whether or not an accused person should be granted bail or bond pending trial. In the Twiba case mentioned above, it was held that, I quote, "Several factors come into consideration, which include the seriousness of the offense, the nature and severity of sentence that may be imposed if the applicant is convicted, and whether or not the applicant is a flight risk." End of quotes. Seriousness of offense as a factor is considered to be a compelling reason when considered alongside other considerations. There is no allegation that the accused person has no fixed place of abode. There was, however, submission that some influential person said he would sponsor the accused person to study law out of Kenya. And this was based on a video clip which, as I have stated in this ruling, was based on a document which was not properly on record, and therefore the credence of that clip has not been established at this stage. The accused person is facing serious charges, but the seriousness of the charges per se would not be a reason in the circumstances of this case to justify denial of bail to the accused person hearing. Next is the strength of evidence. Ms. Rugut for the prosecution submitted that the prosecution reviewed the evidence against the accused person in the course of consideration of decision to charge, and she submitted that the evidence against the accused person is overwhelming. For that reason, she submitted the accused person should not be granted bail or bond on the basis of the evidence against him. At this stage, even though the prosecution knows what kind of evidence they have against the accused person, that information is not yet with the court. The court cannot reach a conclusion that the evidence against the accused is strong merely because counsel has submitted so. I am guided by the authority of Republic versus Sabit, Mamur, Deng and another 2020 EKLR, where it was held as follows, and I quote, "The court was also urged to take into account the strength of the prosecution's case as disclosed by the witness statements in the file. It is noteworthy, however, that Section 123, A, subsection 1, paragraph D of the Criminal Procedure Code makes reference to, quote, strength of the evidence of his having committed the offense, unquote, and for the purposes of the Evidence Act, Chapter 80 of the Laws of Kenya, evidence denotes, quote, the means by which an alleged matter of fact, the truth of which is submitted to investigation, is proved or disproved, and without prejudice to the foregoing generality, includes the statements by the accused person, admissions and observations by the court in its judicial capacity. Thus, such evidence to my mind can only be that which has been duly proved, tested and formally admitted before the court, either by way of affidavits or viva voce evidence, and where documents are involved, such can only be introduced either as annexures to the affidavits or by the makers in the usual manner of production by a witness testifying before the court." End of quote. And the Court of Appeal held thus in the case of Kennedy Nyaga Mwige versus Austin Kiguta and two others, 2015 EKLR, and I quote, "How does a document become part of evidence for a case? Any document filed and or marked for identification by either party passes through three stages before it is held as proved or disproved. First, when the document is filed, the document, though on file, does not become part of the judicial record. Second, when the documents are tendered or produced in evidence as an exhibit by either party and the court admits the document in evidence, it becomes part of the judicial record of the case and constitutes evidence. Third, the document becomes proved, not proved, or disproved when the court applies its judicial mind to determine the relevance and veracity of the contents. This is at the final hearing of the case." End of quotes. These authorities are quite clear on what strength of evidence means and what the court should consider in as far as determination of strength of the evidence is concerned. Whatever is in the police file or the prosecution's file does not become evidence upon which the court can determine the level of strength of evidence against the accused person